Robert and Peter.
Just switch the recording on, Drexel.
Yeah, thank you. So they will go ahead and introduce themselves, but please, as Premier mentioned, ask all the questions that you have. Even if you don't have questions, just ask it anyway. These guys are professionals in procurement, and that's all they do. I don't know who in their right mind just sit down and take a job that does procurement for over 30 years, but I suppose they'll tell you. But ask all the questions you have. So I'll turn it over to Rob, and they introduce the team and continue from here.
Great stuff. Thanks, Drexel. Well, good afternoon, everyone, and welcome. So thank you for the kind introductions that have come through. Much appreciated. In terms of why I would stay in procurement for over 30 years, I entered by accident and have yet to find a way to get out of it. But in reality, it's one of the few functions that is actually incredibly different, because whatever you buy is completely different. Wherever you go is completely different. And you do actually make, well, I like to think I make a difference in terms of improving the return in terms of value for money. So yes, 30 plus years in procurement experience. You can tell with the color of my hair and the fact that it's receding at such a rate. Worked with central and local government, but also worked in a whole series of different private sector organizations, as well as public sector organizations. Areas of specialty. So yes, I've been working through in terms of procurement, working both in UK, but also internationally, in a whole series of developing countries, working with them to improve their procurement, to develop capacity, and also to help them think through about how procurement can help both at a practical level, but also at a strategic level in terms of improving the performance in terms of government. So you can see the list of things that I get involved in, which is pretty much from cradle to grave across the procurement process, and have done for a considerable period of time and still enjoy it. So I'll hand you over to my colleague now, Peter, who has already had a far better introduction than I have.
Yes, but I did notice you started the recording too late, so that was... So as you know, I'm a lawyer, and I obviously don't need to make an apology for a change, and that's very nice. I've also had quite a lot of experience, too many years to remember. I'm a barrister in my day job, so I defend governments and also challenge governments on behalf of suppliers who are not very happy with what's happened. And I've done that in the UK and in the EU. I've also been in front of the World Trade Organization and actually acted as a judge for the World Trade Organization, which was a very interesting experience. Having the United States beg for your indulgence and being able to say no was actually rather nice, although I should, oh goodness, you're recording this, aren't you? I shouldn't say that. But as well as acting in court and defending, I do a lot of policy work on procurement. And so I'm used to drafting regulatory and institutional frameworks and complaint mechanisms. I assess national procurement systems against the available benchmarks and help in capacity building. And as I say, I've acted as a judge for the WTO, and I'm currently the chair of the Procurement Review Board, so similar to your Procurement Appeals Board, for the European Space Agency. So there we go. That's the legal side.
Okay, thanks, Peter. So just really to try and put it into perspective in terms of what we're trying to do. Before we put the material together, I did talk to a number of representatives from the supplier community, and on the basis of that and the wider discussions that I had within government, I've put together a program. So the idea is, and the objectives that Peter and I have got, is for you all to have a factual knowledge of the public procurement law, but also to practically understand how it will be applied and how the individual public procurements will be undertaken. That necessitates the range of skills that in order for you to successfully bid for government procurements within the scope of the new Act, in terms of how it's actually likely to change. Also, to know that there are remedies available within the law that are available to you and will be available to you that you can use to successfully challenge procurement decisions under the framework of the law and hopefully bring clarity and improvement as time goes through. But also there are processes, and procurement has always been process driven, and for you to be able to apply the appropriate processes depending upon the type and form of procurement invitation that's being proposed. And then in terms of your broader perspective, to support the government of BVI to ensure value for money. And I can't stress the issue of value for money strongly enough. It's realistically designed to move away from simply looking at lowest price. Yes, lowest price is one of the options that are available, but it's recognizing that cheapest doesn't necessarily mean best. And it's about being able to take on board those other factors into the procurement decision in order to be able to demonstrate what value for money means, not simply to be seen as the lowest priced organization. So let's sort of put it into perspective, and I will test when we get to the end to see how successful Peter and I have been in terms of being able to achieve those objectives. So to start off with, let's try and put the law into some perspective. And in terms of that, because the word law appears there, clearly it can't be me that can take that on board as a non-lawyer. So I'll hand over to Peter to take you through the next stage. Thank you.
Thank you very much. And Rob is right. The law is in the name, and so we do have to deal with the law. And it's important because the legal framework has just changed in BVI. But what the objectives that Rob was mentioning earlier, those are really what, as practitioners, as procuring entities and as bidders, that's really what we're trying to achieve. And if you can do that well, if you understand the principles and the objectives, then it doesn't really matter what the law says. You would normally do good procurement. It would comply with the law. But for ease of reference, we have a legal framework, and we have to make sure that we operate within it. And there's no magic to the law. It does contain rules, but it is based on certain principles. And what we're trying to do is achieve good procurement. And we do that through the legislation by promoting the public interest through the use of principles of good governance. And these are, I think, common throughout the world. There's no magic in what the principles are, but the way they are applied in different systems might differ. We think that the way they're going to be applied in the BVI through the new procurement law is a good way, and we think that we will succeed in achieving value for money for the government. So we're very happy with what we're training on. We're not responsible for the law, but we're happy that it is as it is, because I think it does suit the outcomes that are needed by the BVI. And the principles are effectively things like accountability. So people need to be made accountable for their decisions. But this really is about making sure that people understand what it is they're doing and make the right decisions. So it's not just saying, well, I'm responsible, so I just have to, take the hit if something goes wrong. It's not that. It's really about looking at what I need to do in procurement, do my planning properly, decide how I'm going to achieve value for money. And that's becoming accountable. So it's not just a legal principle. It's really a question of how you operate in procurement. And the way we do it essentially in procurement is through transparency. It's not just a question of corruption, but that is a problem all over the world. But it's also a question of procurement officers who are trying to do too well. So what they're doing is they're over-specifying. They're trying to buy the best for the government. That's a waste of money. And we have to try to control that. So what we want to do is to look to see what procurement officers are doing and make sure that it becomes transparent so that we can all see it. Partly, as I said, in order to avoid corruption, but also to make sure that they're doing a good job. They have to make sure that the way in which they select the procurement methods is transparent, the requirements, the specifications, are transparent, the evaluation criteria, all of this must be known so that we can check it. The Honourable Premier did say to you that there is a challenge mechanism here. Well, the only way you can use that is if the process is transparent. You have to know what's happened in order to decide whether something has gone well or not, whether there's a possible breach of the law. So transparency for us is a key component of the procurement law, because it allows you to be able to check the integrity of the process and to assess whether there's been value for money, because you can see what's happened. Not just you, but the government can see what's happened, and you can also verify what's happened. And then together we'll be able to make sure that the full objectives are going to be achieved. What the framework does, the law and regulations, which I'll say in a minute, are imminent. It establishes the operational principles and procedures. As Rob said, it's a procedural issue, procurement. So we need to see what the framework is of those procedures and designed for efficient public procurement. And of course, the intention is to increase public confidence in those procedures. And by I think the public is a very broad church, but it certainly includes the suppliers, the bidders, you, because you are part of and you need to have confidence in the system. Because if you don't believe the system works, then why would you bother to tender for government contracts? If they don't do it properly, then you might as well go to the private sector and get a better deal there. So the processes need to inspire confidence in you, and more broadly in the taxpayers. They have to know that their money is being spent wisely. So for all of these reasons, we need transparency, accountability, and integrity in the process. And we believe that the Act that has just been adopted is going to achieve exactly that. So if I explain to you what has happened very recently, in case you're not familiar with this, and Rob will go on to the next slide at this point. Previously, and well, up to last year, there was no special law on procurement. I mean, it fell under the umbrella of the Public Finance Management Act and the Public Finance Management Regulations, which were adopted under that Act, Part 27, if you want to be specific. But the amount of information, the amount of regulation was fairly minimal. The real rules that applied to procurement were found in a procurement unit procedural manual, which was never formally adopted as far as I understand, and in the handbook of public sector procurement, which was only ever in draft. But those did contain fairly significant rules and procedures and processes which would apply, but they weren't in a legal framework, so they weren't really legally enforceable. And the Honourable Premier didn't say it today, but in the introduction to our very first presentation, he said it was a bit like a quiz question. So how do I know what rules apply? Well, frankly, it was very difficult to identify those rules within this framework. So what's changed and what's happened now is that we have a significant act, a Public Procurement Act, which covers all aspects of procurement law. And that's going to be followed imminently by a set of public procurement regulations which sort of contain the details that you need for the Procurement Act. So together, that's going to constitute the legal framework, the legislative framework for procurement. And if you are a lawyer, that's where you would go. It doesn't mean that that's all that is going to exist, because the handbook and the manual, which has been in draft and not, that still exists, and that's going to be upgraded and updated so that it fits within the Act and the regulations. And ideally, that's where that's where the procuring entities would go, because that will explain how the procurement process operates in a non-legal way. It just says, this is how we do it. This is how procurement happens. And that will contain all the templates and the documents that you need. It will reflect what the requirements are in the law, but hopefully you won't need to go and look at the law. It should all be available in those documents. But as a lawyer, of course, I'm going to say we will need to refer to the law, especially if there's a problem. And if we didn't, I'd be out of a job. So please do remember there is a law and regulations that we will need to refer to from time to time. And if we just go to the next slide, I've given you the sort of the general objectives in terms of integrity and accountability, the principles that apply. But the law goes a little bit further. We are trying to achieve very specific objectives. And one of the very important ones is sustainable procurement. So for example, there are provisions in the law which allow you to follow environmentally friendly provisions. So the way in which the specifications are drafted will allow the government to say, well, we want to reduce waste, we want to make sure that we protect the climate through the products and the services that we purchase. And you as suppliers need to know that, because they're effectively setting the benchmark that you have to meet. And so you need to be prepared for that. There isn't a policy yet in place, I don't think, to say what those conditions are going to be, but the law allows it, so it will come. And that's very important. I've mentioned already transparency, integrity, and accountability. They're the words we keep repeating, and I'm sure they'll come up over and over again, but I'm not going to say any more about it now. It requires equal treatment and non-discrimination. These are different concepts. Equal treatment means that you treat all bidders equally, so that you should be satisfied that there is a level playing field and you're not going to be mistreated. Non-discrimination is really a question of unequal treatment based on nationality. So this is, if you it happens a lot. It's the key principle in the European Union, for example, where the rules are designed to make sure that the British don't exclude the French and the French don't exclude the Germans. I mean, that's really what the issue is about non-discrimination. But don't think it's so far away, because I know you're associate members, not full members yet, I don't think, of OECS and CARICOM, but you are associate members. And as you come closer to those, then there may well be restrictions making sure that you can't discriminate against foreign bidders, at least to the extent that they're part of the same regional trade agreement or trade arrangement. So it's not too far away now, but clearly what we're looking at for the moment is that all suppliers are treated equally. And if there's any suggestion that you're not, then of course you are entitled to bring an action against that, challenge it. And I encourage you to, because the government wants to have good procurement, and therefore it depends on you to tell them when it's not happening. One of the areas I always think is important is technical specifications. I know Rob is going to talk a lot about technical specifications in terms of the way you develop them and you draft them. But one of the things that I always find is specifications are a very easy place to have discrimination or to make sure there's unequal treatment. And it's very, very hard to demonstrate that there is unequal treatment. I've actually been standing up in a Supreme Court, dropping stones onto some geotextile to say, well, look, this is just as good as another geotextile and the specification is wrong. But lawyers and judges trying to deal with this, it's very hard. And if you've got supervision, if you've got control, people looking at it, they don't know. But the one person that does know when a specification is discriminatory or favors somebody or other, it's a supplier, it's you. You know exactly when a specification favors your competitor. And so it's very important that you identify that. And if that is the case, then you should bring that to light and you should make sure that people know that by challenging that procedure, because only you will really know it. Nobody in the government is necessarily going to understand that. No lawyer is going to work out technically what's discriminatory or not, but suppliers will. And that's why I think it's very, very important that you have the right to challenge a breach of the law, because having a discriminatory specification is a breach of the law. I'll stop there. I mean, we're going to talk about this later, but in terms of equal treatment and discrimination, the place I see it most often is in specifications, and the only people that can identify that accurately are the bidders. And so you're very important in this whole process, because without you, we're not going to find out when people are doing this in a discriminatory way. Of course, the government wants economy and efficiency. We don't want to spend more money than we need. We need to be efficient. So to the extent that electronic government procurement, for example, may be introduced, that's going to help. That's going to make things go more quickly. It's not the answer, because if the procurement is not working properly, all electronic procurement does is show you the problems more quickly because it's more efficient. So there's more to it than just saying we want electronic procurement. But in terms of economy, there are lots of ways of making procurement economic, but one of them is choosing the right procedures. You know, if you've just got an off-the-shelf product which is fairly simple and doesn't cost much to identify, then you certainly don't want to be doing an open tendering procedure, because that's going to cost money and take time. So you need to develop, you need to work out which is the appropriate approach to market, what's going to be best for you. And I'm talking here about the procuring entity. So economy efficiency, a very important objective. Broad participation and competition. So clearly, we need to have as many suppliers competing for all of the contracts that are available as possible. The more competition, the better choice there is, the better quality choice, the better prices will be available. And so the whole point of this is to increase competition. There are cases where we can't have full competition, in the case of urgency, or if somebody's got proprietary products, then of course we can't have competition. But where it's possible, that's what we try to achieve, and that's what the law tries to say. The purpose is also to simplify, clarify, and modernize. To simplify, really, we need to have consistent procedures throughout the government, and so the possibility that people will use different processes, different templates, different models, that's not helping us, and certainly won't help us, you, the suppliers, because you need certainty. You need to know what's happening, and you need to know what documents to fulfill. So that's one of the purposes of the law, is to make sure that everybody is using a consistent process and a consistency, and that needs to be clear, and hopefully that's what comes out of the law and the regulations. The purpose is also to modernize. So I've said sustainable procurement, that's a very modern concept. The law also foresees things like framework agreements, for example. So a very new tool that's used throughout the government for aggregating requirements and achieving economies of scale. And I've said electronic procurement, although that's not at the moment one of the tools that's being used. The Act does allow for it. So all the preparatory work, if you like, is set out in the Act. So it could happen if the government policy is to use electronic procurement. So I think that's enough on the policies and the objectives. I'm sure as we go through the slides and the discussion, a lot of these will come up, and Rob will be able to explain how some of these principles apply in practice and how we should use them and rely upon them. So back over to you now, Rob.
Okay. Thank you, Peter. And as I say, if people have any questions at any time, please feel free. Either use the symbols with a hand up, or use the chat line, whichever way. Don't feel you have to wait until the end. If a question comes up, please feel free to answer it. And I can guarantee you, you won't be the only person who will want to ask that question. So in terms of the sort of practical thing, what effect will they have? One, it's created a new focus on good procurement. And good procurement is about value for money, which it means taking into account things like quality, things like quantity, things like time, things like place. Once we've identified those and those are clear, that makes the final part of it, which is the price that we pay, much more reflective of what the need is rather than what we would like. It also creates greater comfort for international donors, because the better the system is, then your systems can be applied rather than actually having to apply multiple different systems because of perceived deficiencies. And so because you have a robust system in place, because you have a greater understanding in terms of how it applies, then that reduces what I would call the noise in the system. The less noise in the system, the easier it is to get things done, and the quicker it will be, and the fewer challenges there will be. Because I like to say is, none of us like surprises unless they're nice surprises. And if I could guarantee that every surprise would be a nice one, would be okay. But it's not the case. And so what this is designed to do is to remove the surprise out of the procurement process, because it's clear what's happening. So right from the beginning, from actually identifying what the demand is going to be and being able to circulate through procurement plans what is likely to be bought within the next 12 months across government, then suppliers will have advance notice and can start to prepare what they need to be thinking about in terms of their operation and how best and what they would wish to look to bid for going forward. We want to simplify the procurement process and have consistency, because we recognize that inconsistency in performance and behavior creates suspicion. And suspicion is, well, if it works for one ministry, why does it not work for another ministry? And so we then start to say, well, maybe there's something strange going on. It may well not be. It may just simply be a lack of understanding. And so simplifying the process means that people will understand better how to carry out the process, means we'll be consistent. That makes it easier for bidders to be able to say, yes, I understand what that is. That's a standard form. I'm clear in terms of how to be able to fill that in, rather than having a multiplicity of different systems and processes in place. It also means that we actually have control, and control doesn't mean sort of taking the flexibility and the innovation out of it, but what it means is we now know what it is we're doing. We know what we're spending our money on. We know where we're spending it. We know how best to approach the market. We know what the nature of the market is. So we're not going to set our contracts at different levels, which means suppliers are either too big or too small. So we align those to it because we now know what we're spending our money on and how best to approach the marketplace. We also recognize that we won't immediately become perfect. So there will be things that may need to be improved. And so what we've got now is a framework within there which says any concerns that you have where you think it could be done better, or maybe there's something that is slightly untoward, is we've got a process to be able to flag that up, to be able to identify that, and to be able to address it. And for the actions taken in terms of addressing those to be made known. And so that again is designed to foster comfort within the community, is that yes, we understand what's going on. We may not necessarily like the decision, but we understand how the decision is being made and the base upon which the decision is being made. And therefore we know what we need to do in terms of being able to improve to be more successful going forward. It also means that now we actually have a custodian of risk. Risk traditionally in organizations has been the responsibility of everybody, which effectively means it's actually managed by nobody, because everybody says it's someone else's responsibility. Yes, we recognize there are risks, but that's not for me. And so what this means is that within procurement, we're now looking at risk. And yes, there are risks in terms of fraud and unethical practice, but actually looking at risks associated with those particular procurements. So is there a risk of extended delay? Is there a risk of price changes, etc.? And being able to incorporate those risks into the frameworks that are actually put together. And so we've got, and we've had discussions on two keywords, which I think, one's unforeseeable and one's unforeseen. Unforeseeable are those things that you cannot anticipate. Doesn't matter how good you are. But there are other things which are unforeseen, which means had we thought about it in advance, we could have anticipated what those are. So we know that there will be weather and climatic issues that come through that hit your location. We don't know when, we don't know the severity, but we do know it will happen. And so what we can do is we can set procurements in place in readiness for that to happen, so that if it happens, we've got things that can move quickly. And so we're not left in the position of saying, oh, well, we need to do something now. It's an emergency. We've actually thought that through, and we've got things in place to be able to address them. That then makes it easier and better for not just government, but also for the supply community. And in terms of sustainable procurement, it's just another example of government moving away from buying purely and simply on lowest price. It's actually saying is, yes, there are elements. So in terms of energy use, It's worth buying items which have a lower operating cost and have a longer life than something which is a lower price, but is likely to have a shorter lifespan. And so what government can now do is take those factors into account in arriving at the ultimate decision, which says this is the better one. It won't necessarily be the lowest price, but it will be best value. And if it is that way, you will understand at a very early stage what and how that's likely to be incorporated into the procurements, because there is no point in us putting these things in place without you being aware of them, because we want you to be geared up to deal with them in the way in which we're looking to approach the marketplace. Without that, we have no opportunities. And so communication is recognized as being one of the key things, and this is one part of that sort of process. So how does it impact upon the supply community? One, in terms of exceptions, and there has been historically in government, not necessarily BVI, but in government, that, oh yeah, that doesn't apply to us. And one of the sort of classic things is if it's deemed to be a sensitive nature. And so I've worked in countries where the Ministry of Defence have said, we don't need to follow this law because all our stuff is secret, is top secret. Well, of course, is buying boots, is buying sheets, is buying medicine? No. And so they're not exempt. Those things aren't. There will be some things which are of a very small proportion, which are deemed to be highly sensitive from a strategic perspective, but those will be few and far between. And so each procuring entity shall ensure that they comply with the law. So no one is exempt. Everyone has to follow this, and hence that's what we're doing. And that also includes, importantly, disposal of goods. So it's not just the procurement of those, but it's also the disposal of those which are deemed to be unserviceable, obsolete, and surplus, because we still want to get value for money from those items as well. There are some exemptions, as I say, those things which are very rarely deemed to be of so strategic nature that we want to keep it secret. In terms of some services, so in terms of advertising services, if there is only one outlet in terms of advertising, then it seems crazy that we have to go through a procurement process when there's only one place we can go to. Equally, if we're wanting to travel to location or want to stay in some location, then again, limitations in terms of the choices that we've got. And so those things will be exempt. Employment contracts will be excluded, financial instruments, legal work, not all legal work, but where there is, again, particular expertise that can only be taken from certain points is, again, it seems illogical and time-consuming and inefficient to actually go through a process where the outcome is pretty much known in advance. The same in terms of medical facilities, etc. In terms of goods, then again, if you're wanting to procure a certain building, then there will only be one owner of that. And again, what is the point of actually going through a process where, again, we know in advance what that looks like? But wherever we use exemptions, or items are deemed to be, we have to be able to justify it's exempt under the terms within the law. And so, again, all justifications where people choose to exclude are recorded and subject to scrutiny and will be scrutinized in order to ensure that the decision taken is the correct one. Value for money, and I say, and I can't stress it enough, is because a lot of feedback has come through is, oh, well, decisions are only ever made on the lowest price. And we know in advance in terms of who's going to get that. It's not a case at the lowest price is now. The Act allows for other factors to be taken into account as long as we can determine how they're going to be applied. And so in the bid document, where it is other than lowest price, then the weightings and the components that make up that value for money decision will be identified and usually displayed in a descending order of importance, so that you guys know what it is that you need to consider in putting together your final solution. And I stress, it is cost, not price, that's there. It may well be that cost is determined in some instances only by price, but that again is very rare. So what does the Act place? Well, it places obligations on all parties in there. So in terms of yourselves, your submissions would be excluded if it's identified dealing in corrupt, fraudulent or collusive practices, which would, so examples would be seeking to influence participation. So we should be included in that, whether they have gone through the process or not, affecting the execution of a public procurement contract, allocate procurement contracts among tenderers. It's your turn to be successful. I'm not saying that anyone here would be remotely involved in any of that sort of thing. But again, it's simply stating that if any of these things are actually identified, then those would be clear grounds from which you would be excluded from bidding for business. Where there is attempt to deprive the procuring entity of free and open competition. So placing limitations in terms of being able to control the marketplace through either price fixing or other commercial activities. Be insolvent, in receivership, bankrupt or being wound up. Have any conflict of interest. And I will come on to conflict of interest in a little while. Doesn't mean to say that you may have an interest and that you can't have those, but it's simply about identifying what those are and understanding and flagging those up in terms of how it may impact, because at some point in time, if it deemed to be a conflict of interest, then that may well negate your ability to bid successfully for business. Equally, in terms of being convicted of criminal offences for misconduct within 2 years, or have been subjected to any debarment. Now, debarment as such, and Peter will confirm in terms, it's not something which is actually sort of dealt with at the moment, but it's something which is likely to be considered going forward, to be understand how that intersects some ground rules in terms of those issues. But equally, as a prerequisite, one, have legal capacity, and two, have paid taxes and social security contributions. And also government-owned enterprises, if they wish to bid for contracts, then they must establish a legal and financial autonomy in order for them to be considered. So they have to separate themselves away from government in order for them to be able to consider as an equal supplier potential. From the procurement entity, one, produce and advertise an annual procurement plan. And the recommendation is that that should be done and circulated out widely as early as possible, so that the supply community can actually see, right, so we can see collectively across government, they're going to be spending 10 million on IT, hardware and software. They're going to be spending 10 million on road construction or whatever it may be. So depending upon what business sector you operate in, you can see collectively what the opportunities will be and what the implications will be in terms of bidding for that activity as part of government work. That means if you're prepared, when you put your bids together, again, you're aware of it and you can be doing your preparatory work in advance of that in order to be able to meet the obligations within government. To make sure that procurements are in compliance with the law, and Peter alluded to, and again, it's been one of the things that I've always maintained, is if you do effective procurement, then you will comply with the law, because the law itself places no greater obligations on the procuring entity than would be placed on them as a general commercial operation. All it does is formalize that and bring them up to date in terms of that one. That when they issue bid documents, that the timescales for completion are realistic in terms of recognizing that it takes time and effort for you as a supplier to identify what materials you may require, what services you may require, what resources in terms of people, etc., how you can actually sort of obtain in terms of lead times, etc., in order to put together a meaningful bid. And so it's saying is we will give you sufficient time to be able to put that together. And so it's not a case of, oh, well, you know, there's only going to be one who can win on this one because they're the only one that's prepared for that. No, the timescales will reflect what is necessary for all bidders to be able to complete the document successfully for it to be considered. But the specification will reflect what needs to happen in the marketplace. So they'll have enough information on there. And when I say a fully detailed specification, that's not identifying every nut and bolt, every process to be applied, but it's actually saying is this is what we need it to do. And so think in performance terms rather than conformance terms, but providing you with all the information that you need in order to understand how best you, in your bid submission, can satisfy that need. And equally, that the way in which the contract will be funded and paid is clear. So you understand how the organisation wants it to be paid. Particularly when we come in to look at framework agreements going forward, is that, is it against a fixed rate? Is there some price formula that's actually going to be applied? If we're looking at awarding multiple contracts under a procurement, how that's going to work, how it's going to be costed, how you're going to make in terms of adjustments. All of those things will be detailed within the bid document so that you, again, can put your best submission to reflect what you feel is the best approach. That when bidders have queries or questions, that we respond to those fairly and promptly. So if people ask questions in terms of bid clarification, then we put back a response which makes sense, which is clear, and we do that quickly. If we can't do it quickly, then we make allowances within the timescales for you, again, to have sufficient time to be able to interpret and understand that additional information and how it would adjust your bid submission. That we've got a supplier challenge system. So in terms of where suppliers feel that they have been unfairly treated, then we've got a process in place which says this is how it's going to go, and we'll come to that in a short while. But also have an open and responsive registration and approval process. So actually saying is where suppliers come through, yes, particularly where we're going to look at, say, the restrictive or limited approach, that they've got a means by which you can register your interest and know how that's going to be applied in terms of procuring entity, in terms of selecting potential bidders to submit bids. That everything we do is clear, transparent, and is fair. Also, we as government want the supply community to do better. And so there is a requirement within there which says that if you request, so you're unsuccessful in submitting a bid, and you request, can you explain to me why I wasn't successful, then the procuring entity will debrief you and say, in terms of your submission, these are areas where you didn't perform as well as the one who was successful. And so that then provides feedback to you in order to determine what you need to change in order to improve your chances of being successful next time round. And so it's recognizing that if you get better, if we have to tell you the things that you need to do better in order to be successful. Also, where procurements start, and we recognize again that there are timescales associated with this one, but we actually notify everybody of the successful contracts that have been awarded, but also where procurements have stopped for whatever reason, and it may be a change in demand, change in policy, changing funding, or whatever it may be. But again, the supply community is notified that this procurement is no longer current and has been stopped. So again, you can see, as I've heard information, is we don't know, sometimes for months, whether this is going ahead or whether it's not. Sometimes it does, sometimes it doesn't, but it's very hard to be able to plan and prepare for that. What the Act says is, you report all successful and unsuccessful procurements for people to see and to understand the implications. Also, again, recognizing confidentiality. So where suppliers are innovative in their approach, have particular skills, etc., is to actually maintain what confidentiality applies in terms of bid submission. So it's not about sharing that information from one bidder to another. So in terms of the challenge process, it's about only your information, what you need to do, not what other people do. So we will maintain confidentiality in terms of what you tell us, and equally, we would expect you to acknowledge confidentiality which relates to other potential bidders. And equally, we have an obligation to disclose potential conflict of interest from internally within government. So in terms of integrity, does anyone have any questions? Are we okay? Because I always begin to feel slightly nervous when it's complete silence. So does anyone have any questions on what we've said so far? Okay, I will take silence as either complete shock and horror or full understanding.
You're going well.
Okay, thank you. So in terms of the issue is recognizing in terms of behavior. So we're actually saying is, and there will be a code of conduct in terms of integrity, which says individuals involved in procurement shall be diligent, so shall not be slow in responding, shall be impartial, so shall not favor anyone, and will be conscientious in terms of how they actually deal with things and will deal fairly. And so that's a prerequisite which will actually sit there, and it will again be enhanced further within the integrity code of conduct. Always act in the public interest, so to recognize what the wider picture is, avoid conflict of interest. Equally important in terms of, and what we're saying is this may be actual, it may be perceived or even potential. And so we're saying is flag these up. If you think there may be a conflict of interest, flag it up and let that decision be taken by others beyond you in terms of whether or not you can continue to play an active role within a procurement or whether you need to step aside as part of that. Because in reality, perception is reality. And so whether it's real or perceived, it still needs to be addressed. And again, clearly state not commit any fraudulent or corrupt practices, not seek in terms of solicitation or acceptance of inducements, and not disclose any information relating to procurement proceedings and tenders. So clearly setting out the framework within which procurement practitioners will operate. And again, setting within the code of conduct, which will be issued by the ministry, things which have been there. And these are just examples which maybe, so if you're a director, a partner, shareholder, trustee, officer, or employee of the business entity, or in any other capacity as may be prescribed other than a financial interest. So it may well be that there is a sort of link through on a social side or whatever. Again, recognize those, flag them up. Doesn't necessarily to say you can't do them, but at least people are aware and can take the action to avoid potential concerns coming in the future. In terms of officials, so it will be deemed appropriate where they're in decision-making process. So anyone involved in determining, evaluating, awarding bids as direct or indirect which affect or influence or are likely to affect the ability of performance of a person to perform their job, has financial interest, including a financial liability, has a public procurement function, so means involvement in relation to procurement through either the planning stage, so involved in the planning, or indeed conducting any of the proceedings, so in terms of pre-qualification, in terms of bid evaluation, in terms of supplier appraisal, etc. All of those would be deemed to be an area where potential conflict of interest could be occurred. He's involved in the decision-making process, as we said, and he's involved in the preparation of the bid document. So basically, the general rule is we can exercise influence. Where you can exercise influence, then again, make sure that that risk is managed within the conflict of interest declaration. So again, just to try and do it, and effectively, this is a way of being able to say these are sort of FAQs or situations which would be deemed to be a conflict of interest. And your ability to read will be faster than my ability to speak. And so I will give you a few moments to look at those and see whether or not you would consider them to be conflict of interest or not. Okay, does anyone think any of those on the list would not be deemed a conflict of interest? In which case, again, I will take silence as being agreement. So these are simply examples of what would be deemed to be conflict of interest. So in terms of paid services on your time off to an organization, so this would be where an individual says, I work part-time, so you're going to put together a bid on there. I can help you put together your bid. As part of that would be a clear conflict of interest if they themselves were at some point in time going to be involved in the evaluation process of those bids. Okay. So in terms of sort of process, what are the consequences are there for non-compliance? And because law appears at the beginning of this slide, we now know where this is actually sort of going. So before I hand over to, does anyone have any questions or queries on what I've just talked about? In which case, Peter, over to you.
Okay, so thank you very much. So we're going to go back to the law again, but only to really give you an overview of what is in the legal framework so that you can identify it. I mean, some of it I'm not going to go through in great detail, but clearly this slide, based on what Rob has discussed up to now, is to consider what the consequences are for non-compliance. Well, Rob has explained very well that there is now a possibility for a legal challenge. So if the procuring entity doesn't comply with the law or the regulations, then suppliers are entitled to bring a legal challenge. And don't be afraid of this. I think this is something you have to be, you have to learn to do. You need to bring a legal challenge if there is a breach or a potential breach of the law. There could be criminal charges. Now, this sort of happens outside the public procurement law, but if there is any suggestion of corruption or misrepresentation or fraud, yes, as a supplier, you would be rejected, your bid would not be considered, but there could be a referral to the appropriate bodies to take that further forward. So there is a potentially greater risk, and this applies to the procuring entity and the procurement officers more than to you. But to the extent that that you're implicated in bribery, for example, or collusion, there may be consequences at a criminal level. I'm not familiar with all the ramifications in BVI, but just be aware that it's not only the legal challenge under the Procurement Act, it is all the other possibilities within BVI. But more practically, and getting away from the law a little bit, non-compliance will lead to operational delay, so the procurement may not proceed as quickly as anticipated. They may not get to the result they wanted. The time for delivery may well overrun, and of course that's a big negative consequence for the taxpayer as well as for the government. A duplication of effort, because if they get it wrong the first time, they may have to redo it, which case they're going through the whole process again, and that's a significant waste of money, a significant cost to the government, and all of this leads to significant inefficiencies. Clearly, that's not the way to proceed with procurement. So all of this to say that really compliance is what we're trying to achieve, and there are provisions in there to make sure that that is enforced, notably through the possibility for legal challenges. I don't think any of that comes as a surprise, Rob.
No, I was just going to say, in terms of the operational delay, is effectively one of the key things there is any challenge that's made effectively stops the procurement. So the delay operationally may be unfortunate or unhappy in terms of the government, but what it means is that if you have a claim or a challenge which is being addressed, whilst it's being addressed, the procurement stops. So they can't suddenly say, whilst you're challenging this, let's just slip the contract through. In the meantime, no, it has to stop in order that the challenge that you make can be heard and can be determined. And so operational delay can work in both ways.
Yeah. I should just add there as well that there is an automatic suspension, so the procuring entity can't proceed to the extent that there's a challenge. But if it's in the public interest to proceed, they can make an application to allow it to go ahead, but they have to demonstrate that that's an urgent necessity and in the public interest. Do you want to go on to the next slide?
Indeed.
What I want to do now is just go through some of the bodies involved. Now, some of this will not be new to you, some of it will, and we've got quite detailed slides. I'm not going to go through every single function, but I will generally indicate what all of these different entities are doing. So if we go to the first one, the ministry. The ministry here means the Ministry of Finance. That's how it's defined in the Act, but we tend to just say the ministry. So it's the minister and the financial secretary within the ministry. So they have a number of different functions. Particularly, they formulate and issue the public procurement policies of BVI. So they decide how procurement is going to be changed. And of course, they put forward the bill, which has now become the Procurement Act. So that's the sort of source of the policy. And they will also issue directives and guidelines to implement the law as we go along. And they're clearly responsible for the execution of the public procurement policy of the government. They will, as part of their monitoring of the system to make sure that the procurement system is being applied and implemented effectively, they will present an annual report to Parliament on the overall functioning of public procurement. And it's on the basis of that that they would propose new legislation or new policies. They also appoint members of the Central Tenders Board and the Procurement Appeals Board. And to the extent that a challenge is made, they would forward the request for review to the Appeals Board 7 days after receiving it. Now, this isn't to say that they take part in the appeal process in the legal challenge, but somebody has to act as the secretariat. Somebody is the registry of the cases of the complaints. And so that's carried out here by the Financial Secretary's office, and they will then send the challenge to the appeals board. So it's really a logistical function rather than any judicial function here. If we go and then have a look at the Central Tenders Board, they will be doing some policy and guidelines in the sense that in particular they would be recommending policy and legislation changes, and they adopt standard procurement documentation. So from your point of view, it's very important to have a look at what they're doing in terms of policy and the documents that they provide, because that's going to help you. That's going to standardize the whole process, and those are the documents that the procuring entity will be using, and you need to understand, because these will be used across the government. So this is where we're trying to get some consistency and legal certainty. They will also be establishing and maintaining a public procurement website. That's primarily about information. So if you need to get copies of the law, the regulations, the guidelines, that's where it's going to be. I don't have the address, sadly, but that's where you're going to find the information. And ultimately, that may well be the place where you will see advertisements for procurement opportunities. They're going to be advertised there as well as in the newspapers. But I think possibly the most important thing here for your purposes is that the Central Tenders Board is the one that's going to be approving the award of contracts where the value exceeds $100,000. Above $250,000, it's the cabinet that approves it, but for all others, it's the Central Tenders Board. And they will be recommending the awards to the cabinet as well. So everything will go through the Central Tenders Board. In terms of the procurement unit, this is the procurement unit within the Ministry of Finance. And for all open procedures, open tenders above $100,000, they are the ones that are going to be managing the procurement process. So it's a very centralized procurement process, and that's going to be your port of call. So they won't be deciding on the specifications. That's going to be the procuring entity, but they're going to be packaging that in the standard bidding documents. They will be advertising it. They will be processing it. And that's where you will be looking for information. If you have, Rob mentioned, if you don't understand anything in a procurement document, you are entitled to seek a clarification, and you would be sending that to the procurement unit for contracts above $100,000, because they're the ones that are managing the procurement process. They, of course, would then communicate and coordinate with the procuring entity, because clearly they're the ones who have the information about their particular procurement needs. But your port of call is going to be the procurement unit. And of course, they monitor the implementation, and they maintain the records and so forth. The other entity that you're going to be interested in is the Procurement Committee. And this is the committee within the procuring entity itself, and it is responsible for managing the procurement below $100,000. So this is then your point of call. They will be doing all of the work, not only setting the specifications, but they will be preparing the procurement documents. They will be issuing the new notifications. They will be responding to bid clarifications, and they'll be monitoring the implementation of the contracts that they award. So that's below $100,000. So that's really, I should say that the approval mechanism parallels this. I'm not sure we have it. We do have a table somewhere. The approvals mechanism is that for all contracts that are below all contracts below 100,000, it's the Procurement Committee that approves it. Above that, it's going to be the Tenders Board, and then above up to 250,000, and above 250,000, it's the Cabinet. The other body that we've mentioned, and this is the Procurement Appeals Board. So this is where you would send a challenge if you have it. We're going to talk about this a little bit more in detail later, but let me just say that where you believe there has been a breach of the procurement law or the regulations, your first contact or your first port of call is the procuring entity itself. So you would go to them and say, hey, look, we think you've breached the law, perhaps it's a mistake, why don't you go correct it? And the procuring entity might say, yep, you're absolutely right, this was just a mistake, we'll correct it, and then we can proceed on that basis. And that will solve the problem. No confrontation, no contentious issues at all. But if they disagree and if they say, well, no, that isn't a mistake, that's deliberately what we wanted to do, and we don't think it's a breach of the law, then if you're still not satisfied, at that point, you would send the complaint to the Procurement Appeals Board, which is independent of the procuring entity, and they would hear that appeal. The membership of the Procurement Appeals Board is chairman is the chair. The chair is an attorney at law with experience in a lot of experience as a lawyer, and there would be 2 additional members appointed by the minister. The identity of those members is not set out, but clearly it would be somebody who was had some sector experience or procurement experience, so that they would be the right people to hear disputes. As I say, this is independent of the procuring entity, and they would then hear your challenge based on the documents, on the facts, and taking into account the response of the procuring entity. They hear and determine the challenge, and their decision is usually or is supposed to be made within 28 days. Finally, there is the accounting officer. I'm really not going to go through this in great detail. The accounting officer is who signs off on all of these procedures below the relevant thresholds. But I think you'll be dealing more with the committee and the procurement unit. I don't know, Rob, if you wanted to say more about that.
No, I'd say the only thing I would say is in terms of approvals, and just to sort of confirm what Peter was saying is, so effectively below 10,000, it's the accounting officer. 100,000, it's the central tender board. 250,000, it's the cabinet. Is the approvals process that will actually sort of follow through. But I'd say that this is just here in terms of how the sort of mechanics and what the sort of numbers look like. And what really it's saying to government is these are the parameters within which you can operate. And so everybody's now clear, rather than can I do this, can't I do that? Oh, I did that, I didn't know I couldn't do that, etc. Now what the Act has done for the first time is actually sort of clarify what people's roles and what they can and what they can't do, which again simplifies the process, makes it clearer, and avoids any potential confusion.
Yeah. And then to the important bit in some ways, which is what are the procurement methods? And this has changed. So I think it's important for you to know what the position is. Now, some of these methods did appear before, but they weren't particularly clear, and I don't think there was much certainty about how they operated, because they were found in those draft and unadopted handbooks and manuals. So now it's very clear in the Act. There are specific methods that are, or procedures, if you like to call them that have been mandated. The Act contains the grounds for using these different methods, and they contain the procedures for using it. The detailed procedure you will probably find in the regulations, but the main elements of the procedure you will find in the Act. We cover goods, works, and services, and as well as consulting services. But consulting services are treated slightly differently, because you have to look at them in a different way, because they're what you're trying to get at is quality. Of course, you need to look at the cost as well. It's balancing quality and cost. The problem is that it's very hard to set a very objective benchmark when assessing quality of consultants. If you're looking at works or goods, you have technical specifications, and the bidders can either submit bids that meet those technical specifications or not. It's quite easy to assess whether they meet the standards or not. When you're looking at consulting services, it's very hard, because you're trying to assess qualifications and experience. And so you can't really assess them in the same way as you would goods, works, and physical services. So there are separate methods for assessing those and evaluating those. In terms of goods, works, and services, there are effectively four procedures: open tendering, restricted tendering, request for quotations, and single source. Open tendering is generally the default, and it can be used in either one or two stages. Generally, you'll be looking at one stage. Two stages are used where, or the government would use two stages, where it really is looking to the supply community for help, because they would use it where it's not so easy for them to absolutely define the technical or the contractual requirements that they're looking for. So they would come to you, the market, and say, look, this is what we think we want. Now you tell us if that's right. Tell us if technically it's correct, whether, contractually this is the way we can do it. So they would have a first stage where they would go to the market and say, look, this is what we think we want. Now you submit a bid, no prices, no financial element at all. You just tell us technically whether we can improve on this or whether we've got it right. And then in the second stage, after considering all of those proposals, they would actually refine what it is they were looking for. And then all of the bidders who supplied a technical submission in the first stage would then be invited to bid against the new technical specification. So this is really using the market to help them define what they want, but it's done in a very competitive and a very transparent way. So it's quite a good process, but the government would only use this for very complex contracts, maybe where there's a public-private partnership. So any large infrastructure like a new airport or a port or something like that, this could be used there if they're not entirely sure of all the technical solutions that are out there, and they would come to you as the suppliers to help them work out whether they were going in the right direction or not. Open tendering can also be used with or without pre-qualification. This is usually used where it's very high value or complex. Not complex in the sense that they don't know what they're looking for, but complex in the sense that it's technically technically complicated project, and people need to look at it very carefully and may need to do lots of site visits and might need to make lots of calculations about how they're going to meet the requirements. And so there, it's a process that is normally very expensive and very time consuming. So for some very large infrastructure projects, for example, you might be looking at a 12-month bid preparation time, and it could cost, I don't know, up to $1 million US trying to prepare the bid for a very large contract. And particularly if you're doing a public-private partnership, there's a massive cost involved in preparing the tenders. Now, since there's only one contract up for grabs, having 10 bidders prepare bids at $1 million upwards is really going to be a waste of time for 9 out of 10 of them. So, and for you'd have to read and evaluate all of these different bids. So it's a large undertaking. And so for that reason, you might want to reduce the number of bidders so that it reduces their costs, so they don't get disgruntled. You don't want unhappy bidders, you might want them another time. So you don't want them to waste their time preparing very expensive, lengthy bids if they don't really have a chance of winning. So at the pre-qualification stage, what you would do is you would try to filter out those bidders who don't really have a strong chance of winning. You would only pick the few that you think are likely to be in a position to win the bid. So then you don't waste their time or your time in having big proposals, lengthy proposals made. So that's when you would sort of use pre-qualification, and the law has a method for doing pre-qualification.
Yeah, and the pre-qualification criteria that will be used would be identified in advance, and once it's set, couldn't change.
Yeah.
So again, before we go, so it's not a case, right, so on what basis? It would be known in advance what the criteria would be used. There would be a formal process that would actually go through in terms of being able to evaluate and make that decision in terms of which ones pre-qualify and which ones don't. And again, if they don't, you would have the opportunity to be able to understand on what basis did you not meet the pre-qualification criteria. And so because it is done in advance and it can't change, then again, it makes it clear what's going to happen and how it's going to work.
We've mentioned already value for money, but we've talked about that more in terms of what you're buying and how you decide what to buy. But it also applies to a certain extent in the methods you choose, because open tendering is an expensive process. There's advertising, especially if it's international. That could cost quite a lot of money in advertising in international periodicals. But if you're only buying some relatively low value product, then it may not be worthwhile going through that process. It may cost you more to conduct the process than the savings that you're likely to achieve. And in some cases, there's only a limited number of suppliers out there. So for power generating equipment, there are 3 or 4 producers worldwide. And it doesn't matter how much you advertise, you will still only get the same 3 or 4 bidders who are responding. So there's no need in those cases to go out and do an expensive open tendering procedure and take the time. You're entitled under the Act to undertake a restricted tendering where you either just invite that limited number of bidders that exist to provide a bid, or you can actually, where the cost is disproportionate, you can limit the number of bidders that you're going to invite. Now, I have to say that this is a bit of a tricky area, because this law, and neither this law nor any other that I've seen, really explains how you select the bidders for this sort of restricted tendering, where you're expecting a lot of bidders to bid for something which is a fairly standard product and relatively low value, not very low value, but relatively low. One of the ways of doing it, and one of the ways that it might be done in BVI, is to use a contractor registration system, and that's already foreseen in the Act. So if you had contractors registered and classified on the system that is proposed, then you would be able to invite all of those to bid in a restricted tendering procedure without advertising the process. But that's going to require a bit more guidance later. But the method is foreseen in the Act. Now, for very low value contracts, and this is below $10,000, there really is no need to do open tendering. It isn't value for money to go through a very long and formal procedure. But there is a procedure nonetheless which does guarantee competition. That is that the procuring entity can send out a request for quotation. Now, this will include a specification. It will say, this is the product I want, this is the standard it requires, this is the time of delivery, and so forth. So there will be a specification, and that will be sent to at least three potential bidders. Should be much more than that, but at least 3 bidders, and they will be asked to quote. The difference here is that the award will be made only on the basis of the lowest price, so there won't be other criteria. This is a simple off-the-shelf product. There's nothing tailored about it. None of the products or the services are going to be designed specifically for the procuring entity. It's just what exists on the shelf, or a very basic service. And so there's nothing more really needed than the lowest price. Of course, you have to decide whether that is appropriate, and if it isn't appropriate, you could still use a tendering procedure even below 10,000 if you really needed that. But the possibility, the opportunity is open for contracts for off-the-shelf products, standard services, to use requests for quotations where the value is less than $10,000. And finally, there's the single source method. This is very important, I think, not because it's a particularly special method. It's used worldwide, but I think because this didn't exist before in BVI. I think this is what they used to call a waiver. So if they didn't really want to have an open competition, they would, for reasons that are probably the same as the ones that are set out now in the law, they would seek a waiver and not apply the law. The difference now is that the law tells you what the conditions are under which a single source or direct contracting method is available, and in order to use it, there has to be a justification. A procuring entity has to be able to say, I meet these conditions and therefore I can use it. And that will be recorded. And that is something you can challenge. If you think that that's wrong, you can challenge it. It's a decision that is open to the challenge procedure that's set up. I'm just going to go through the conditions in a minute, but for the moment, let me just switch quickly over to consulting services. We did mention clarity earlier on. I have to say, I'm not sure the terminology used in the case of consulting services is particularly clear, but there's a sort of historical reason for that. And there is some international legislation or model legislation used, which does use this this terminology and doesn't really help us, but it is what it is. We have this terminology, but basically instead of doing open tendering, we do a request for proposals, and it's very much the same. You write to terms of reference and send it out to consultants, and they need to bid against that request for proposals. They submit proposals. The difference is that in some cases you will be able to negotiate, and in others you will not be able to negotiate. So I will mention in a little bit which of those cases, but effectively, if it's very easy to set the terms of reference, if it's not so complicated, and if it's very clear from the terms of reference what is needed, then you probably don't need negotiation in order to conclude the contract. Where you have something more complex, where there's a more difficult issue of quality and cost, or where you only rely on quality, then there may well be a need to rely or to look to have negotiations to make sure that you're not overpaying for the quality that you want. So that's the slight difference in terms of requests for proposals. You can also have, in fact, you almost always have a pre-qualification procedure here, but it's called pre-selection. You may know it as shortlisting under some of the under some of the rules that you apply if you're using multilateral development bank rules, but it's effectively the same. You would limit the number of consultants who are going to put forward proposals. The main difference, I think, between pre-qualification and pre-selection or shortlisting is that in pre-qualification, if the bidder meets the conditions of pre-qualification, they are invited to bid. In the case of shortlisting or pre-selection, the procuring entity will say, well, it doesn't matter how many meet my qualifications, I'm only going to invite between 3 and 6 or a maximum of 6. And so it's not a pass-fail situation, it's a decision they make based on how many they've received, and they will say, well, we'll take the best 6, for example, and they will go through to the next stage. So that is a slight difference, but it's the same principle. We're going to pre-qualify and limit the number of bidders that we're going to ask to submit proposals. And then there is single source. In this case, it's not so much that you need to justify the use of single source. If the value of the contract is less than $15,000, the procuring entity can simply single source this contract. There isn't an equivalent for goods, works, and services, or perhaps there should be, but it's set out very clearly for the purposes of consulting services that there is this low threshold. So maybe I can now just talk in a little bit more detail, so just so you can understand some of the key elements of this. Above $100,000, open tendering is the default method. If the value is below 100, I mean, it can be very high value, of course, but 100,000 is the key. If it's below that, then the procuring entity can limit the bidders to domestic bidders. So all of you who are based in BVI might have a preference in those cases, or you might be the only ones that are able to bid. But above 100,000, it still may be, you still may be the biggest beneficiaries, but in theory, then international competition is also permitted. One of the things that we really do want to mention, and I don't know how familiar you are with this, is that the open tendering method is also used to conclude a framework agreement. I don't know how many people are familiar with, maybe I will just explain it anyway. And really, a framework agreement is not a contract. I should say that straight away. So the procuring entity is not going to conclude a contract at this point. This is really a contract or an agreement to contract in future. Okay, I always think that's the easiest way to look at it. So we agree now what the contract will be later. And when they would use this, for example, is where they want to aggregate their requirements. So instead of just buying, one set of paper that they need for this month, they would say, over the next 3 years, we are going to buy this amount of paper. For the whole organization, this is how much we're going to buy. We don't know exactly which quantity which office needs at what time. We don't know which location it's going to be delivered, but we know roughly this is how much we're going to buy. So we will agree now for the next 3 years, the terms and conditions of the sale and the price that is going to be paid. So for the supplier's point of view, it's quite important. You have to understand the risk here, and you're going to have to calculate the risk in terms of meeting the supply requirements of the procuring entity. And at the end of this process, which is competitive, the procuring entity will choose maybe 1 or 3 or 5 different suppliers to be able to supply the product or the services that they're asking for. And that's it. There's no contract. It's just you've agreed that you will supply on these terms at some point in the future. You will have an idea of how much it's going to be, and that, as Rob will undoubtedly say, is very important, because if you don't know roughly what quantity you're going to get out of it, then of course, how do you price it properly? Because the idea is that the government will be making an economy of scale, but you're not going to offer them a very low price if you're not guaranteed a pretty good quantity. So all of this needs to be worked out, and it's very important. But what happens is this agreement sits there and nothing is sold until the procuring entity or one of the members of the group of procuring entities, however it's organized, when they want product, they can then come to you and say, you agreed these prices, you agreed these terms and conditions, so deliver this to me tomorrow or in a week's time. There's no more competition. You don't have to make any bid or anything. You've done that. It's simply a question of calling the contract off. In sophisticated agreements, there may be a little mini competition where you're allowed to say, well, you didn't identify exactly where and when and how much you wanted delivered. Now you've got it, so I can give you a more accurate price for what it is you want. So there could be this little mini competition. And it's used for fairly basic things mostly. It could be office stationery and equipment. So there may be sellers who supply all of these things. And it's quite useful to have a nice big contract, and then you would be able to deliver to different parts of the organization over, let's say, a 3-year period. So it's a very flexible thing, and I think suppliers tend to like this. But for the 3-year period, it's a closed market. So if you didn't get onto the framework agreement, you're not going to supply for another 3 years. So there is a slight downside to it for the market. Oddly, you'd think that it would only benefit large bidders, but there's plenty of research out there saying that SMEs rather like this. And I think it's probably because SMEs are more able to plan in this case. If they know there are these different quantities coming at different times, they could actually bring in stock to meet the supply. Whereas if it was a one-off contract, they wouldn't have enough supply at that particular time. So I'm wondering if it helps the strategic planning for SMEs, because they clearly do like it. At least the research that there is suggests that they do like, which is sort of counterintuitive because you think they wouldn't, but who am I to disagree? If they like it, then that's the way it is. One of the things we've been talking about, and this might be particularly because I don't know, I think the government is quite keen on this, at least it seems to be, and that is that a framework agreement is very useful for emergency situations. Rob has already told you about the difference between unforeseeable and unforeseen. And this is a thing about weather conditions, actions, is that we know there's going to be a hurricane. Unfortunately, it's the situation you're in. We don't know exactly when it's going to happen, and we don't know how big it's going to be, but we know it probably will happen, and it'll happen in the next 3 years or so. So instead of scrambling around when it happens to try and find the products that you need and the services that you need, and being held to hostage by suppliers who've got all the answers, then one way of doing this is to set up a framework agreement. And let's say, you can identify, in the case of a hurricane, we know we're going to need fresh water or water making facilities. We're going to need medical supplies and services. We're going to need emergency repairs. We can identify, because this happens sadly far too often, but we can identify the goods and services that we need. We can even identify the historical prices. And so what we can then do, what the government could do, is set up a framework agreement for emergency situations, do a competition so everybody is free to compete and offer the prices. And of course, they're not going to be the same prices. You're going to take into account the prices that you might have to apply in an emergency situation, given the fact that you have to source it from somewhere. I mean, all these sort of things will be taken into account. But then when, you would then be put onto the framework agreement, and when the emergency happens, the government can then simply pick up the phone and say, right, we know what you've said you can deliver at what price, do it today or tomorrow. Okay, no more competition, nothing, no more negotiating, no more arguing. It's all been agreed, and therefore it can be done fairly swiftly. And it would be done with more than one supplier. So if one says, oh, well, actually, I don't have it anymore, I didn't think of it, then the next supplier can come along. Also, no competition, no negotiation, it's all agreed. So I think this is one area which might be explored for framework agreement. We're not there yet, but just so it's just trying to explain to you what a framework agreement is and how it could be used. Do you have any questions on that? Because I think it is quite a complex arrangement. It's a very good one and a very flexible one, but sometimes it takes a while to put it in place, and it can be a bit expensive. Anybody have any questions on it? Again, you don't have to ask now, because we've got the chat, and we also have a Q&A session. It's just that sometimes as you're going through, you might say, what the hell is this guy talking about? I need him to be clearer. So please, if you do, just say so, but you're very welcome then to write it in a chat.
But framework agreements as well work well for services, so particularly consultancy services. So it may well be that you actually have a whole series of different consultancy services. Civil engineers, could be architects, etc. And you say, well, we need your services. We don't know when, where, or how, or who. And so you can actually go through and agree the sort of basic rates in terms of how that would apply. And then as individual projects come through and can simply work through, it then speeds up the whole process. So we don't have to go through the whole procurement process again, because we've done it once. It's all done and dusted. It's much easier, much quicker, and everybody's then clear, and we know who and where we can go to.
Yeah. I said that open tendering could be used in 1 or 2 stages, and I went through it a little bit. I didn't intend to go into such detail on the general slide, but just to reinforce what I was saying. The government would probably use this where they can't fully define the technical or contractual aspects of procurement. And when I say contractual aspects, I mean, if they're doing a public-private partnership, then the contractual arrangements between the financiers, the banks, and the consortium that's going to do the work, for example, that becomes really very complicated. As a lawyer, I would always advise the government to do a PPP, because lawyers make a huge amount of money out of it. As a matter of policy, I would always advise the government against using a PPP, because really it's far more expensive than actually just buying a project. So, it cuts both ways, but it's in those sorts of circumstances you would really need more than one stage, because you have to discuss quite a lot of issues in terms of the risk allocation is really what the big problem is there. And also because of the nature of the goods, you need to have different technical solutions. So let's say the procuring entity has a good idea of what it wants, but is aware that there may be other technical solutions out there. So it's going to seek the assistance of the supply market to say, look, this is what I think I want. You tell me if this is really what I need, or if there's something better out there.
And also it helps the contractors to understand what it is actually that they're doing, and you can see whether or not realistically they can satisfy that need as that need becomes clarified. And so you may well end up start off with 4 or 5, but effectively you get down to 2 or 3 once that is tidied up as part of that process.
Yeah. So very
Right,
useful.
okay.
And
We've got a question from
good.
Tabelio. I hope I pronounced that right. What is the difference between a letter of intent and a framework agreement while the final contract is prepared? Do you want to do the legal and I'll do the procurement, or do you want me to do it the other way?
Okay, well, a letter of intent is really when you've already decided you're going to sign the contract, but you haven't got around to signing the contract yet. So that it's more like a draft contract, if you like. You say we're going to get on with it. Whereas a framework agreement isn't a contract at all. A framework agreement is simply, you know, the terms and conditions that you will apply when you decide to do a contract. So legally, they have different functions.
From a practical perspective, I would always advise against the use of letter of intent, because invariably letters of intent are actually sort of given when we're almost there, we've almost finalized everything, but there's just a few things left. And it's usually the most complex and difficult things which are left outstanding. That's why you haven't resolved them. And so to give a letter of intent without clarifying those, I think is too high a risk for the client. In terms of a framework agreement, you've already gone through that. So you've finalized all the details. So there's no things which are left outside that haven't been agreed between the contractor and the procuring entity. And so it makes it easier and simpler for both parties, because there's nothing which is unclear, and there's likely to be nothing that will lead to a dispute at some point going down the track. A letter of intent, I always find, is almost guaranteed to give you at some point in time some dispute that will arise, which could have been avoided. Always
dangerous. Letters of intent are terrible.
Does that answer your question, Tabelio? Excellent. Thank you. Thank you for that.
Okay, so we'll go on to the next slide, which is just about pre-qualification. Again, I've already explained this more than I intended going through the general slide. So again, it's appropriate in cases of large scale and technically complex and high value project where you're really trying to limit the number of bidders for cost and time reasons. When we're looking at domestic procurement, it may be similar to this contractors registration and classification system. So in a restricted procedure, it's not exactly the same, but it sort of is an analogy. You can compare it to this. In a restricted procedure, you could be using the contractors registration and classification system as your first point of reference, if you like, for inviting contractors. I will say it's not the same as pre-qualification, because pre-qualification is normally very contract specific. You can't really pre-qualify people unless you know what they're being pre-qualified for. In a classification or registration system, you can certainly ask for some general criteria. You know, are they registered companies? Do they have a license to do this? Do they generally do very large contracts? Do they generally do only bridges? So you can go through those sorts of issues, but you still couldn't pre-qualify them for a specific contract. But there is an analogy there, and you can see how it would be used in the domestic contract context for restricted procedure.
And it also provides the client with an indication that people who are registered on that system are interested in submitting genuine bids, rather than someone who is, well, I think I could be, or whatever. They've actually said, no, this fits within mine, I'm interested. And so there has been some pre-intent to be able to want to bid for government business.
Then so moving on to restricted tendering, again, I explained this more than I intended earlier on. So it can be used in two situations. First, where there is only a limited number of tenderers available. And I mentioned the power generating equipment. If there's 3 worldwide, there's 3 worldwide. And it doesn't matter how often you advertise, you're still going to get the same 3. Now, in a domestic context, this is more difficult because you'd have to work out why you know there's a limitation. And here you could look historically and say, well, every time we've opened this to competition, we still only get a limit, you know, these 3 contractors, and they are the only ones that are available in country. Now you have to justify it in one way or another, but there may well be situations outside the very strange case of power generating equipment. There may be cases where even if generally many tenderers could supply something, in the context of a particular country like BVI, there are only a limited number available who can do it. But you have to justify that. And if that is the case, if you can demonstrate that, then you could, the procuring entity could just invite those 2 or 3 bidders. If there are more, then you should still have competition. It's only where you really have only 2 or 3 and nothing would be gained by doing competition.
And the justification indicates an active approach to assessing the marketplace rather than a passive approach. So the fact that you have to justify that there are only 3, or we approached others who said for geographic reasons, for whatever reason it may well be in terms of logistics, it's not practical for us, or we don't see ourselves wishing to go in that marketplace. And that's fine. Saying actually says, yes, I know that other players out there, we've approached them, we've got evidence from them to say that they're not interested in bidding for our business for whatever reasons it may be. Therefore, the fact we've only gone out to 3 suppliers, it means that we still can ensure or demonstrate that we'll get best value for money, because those are people who are likely to be able to submit legitimate bids.
Yeah. And like Rob said, you have to be, the procuring entity does need to be proactive, because there is always the chance there'll be a new market entrant. If they see there's only 2 or 3 people bidding and the prices are high, they may, oh, well, I can do this and get a better price. So it has to be revisited from time to time. It's not something that you can just, the procuring entity can just rely on. And then the second condition for using this is where the time and cost required for evaluating a very large number of tenders, and that is where you know it's a fairly standard product and there are lots of people out there, where the time and cost would be disproportionate to the value of the procurement. And this provision is in the law. It's a provision that you find in almost all procurement laws, not everyone, but equally no laws explain very clearly what it is, how it is you limit the number of bidders. All they generally say, as does the law in BVI, that you have to choose them on a non-discriminatory basis and you have to have a sufficient number to ensure competition. So those are the conditions, but that still doesn't tell you how you go out and determine them, which is why, at least in the case of works, the contractor registration and classification system that's foreseen in the regulations that are imminent is very helpful. But there is a risk here, of course, and if you see as a supplier that this is being abused, then it's really up to you to challenge this and to say, but why is this? Why are these bidders, and if they're always the same ones, why are they being always asked to bid when there are plenty of people out there? So if this is abused, then really suppliers ought to be challenging it. It isn't particularly satisfactory, but it is very common as a provision.
And so again, the evidence in terms of looking at things like that, because this information is published, then it's clear to be able to see. And what I would always look at is there should, if you see trends appearing, then you get suspicious. And so it's again the same sort of thing. Look at that. Within that, equally, we're as concerned about that from the procuring entity side, and actually saying is, yes, we recognize that may happen, and you have to be able to justify on those instances. And if the suppliers feel that that's not happening properly, they can challenge that. And again, the appeals board, or whichever point it goes to, would have to be able to look at the document, says that justification is insufficient, therefore you will need to change, or that justification is sufficiently robust enough, it's fine. And at which case that information will be fed back to whoever makes the challenge, and they could then decide whether or not to take it further or to pursue a different approach.
And then the possibly the not quite the least competitive, but the one where competition is a little bit more restricted is under requests for quotation, which is the next method that we have. And this is used only for procurement with a value of less than $10,000. So it's not for particularly expensive products. and it's used for routine works and maintenance. So maintenance of air conditioning units, even of vehicles, or electrical and plumbing services that you need on a regular basis, or readily available goods and services, things that you need on a daily basis, things that are not specifically produced for the procuring entity. So it's not, they're not designing anything. They're not saying this is what we want specifically. They're just going out and buying what there is in the market. And it has to be an established market. So there has to be plenty of it around. And in those, yeah, carry on.
No, I just say, and also consideration would also be taken at the time of the original bid exercise as to whether or not, if we're looking at whole life costs, to include routine works and maintenance as part of the original procurement that was carried out. In which case, then a request for quotation would be post that time into the life. So if the life is 5 years, it may well be that there's routine works or maintenance beyond that which haven't been incorporated into it. But again, good practice would be include the routine works and maintenance within the original procurement, and that way it's clear, so you don't get, again, potential disputes which arise between this was a fault by the people who built it, no it's not, this is the fault of the people who maintained it, and that's the last thing that we want to get to.
And if you fail to do that, if your planning wasn't robust enough to do that, then it's also somewhere where you could use a framework agreement. If these are continuing services, works and maintenance or goods and services that you want, rather than just do multiple requests for quotations, which are not particularly competitive, then you could do a framework agreement and have a call off. And I should just, it's something I should say, is that under the new act, procuring entities are not permitted to fraction their contracts. And what that means is they're not allowed to split up a contract into such small units that they avoid competition altogether. It's very easy to say, well, I'm going to buy toner for, every month for the rest of the year, but I'm only going to do a request for quotation for 1 or 2 bits of toner because that comes under $10,000, and therefore I'm not going to have to do a competition. If they're buying something consistently, then that has to be aggregated at least over a 12-month period. And so they would have to do a competition. It's unlawful to break it down to such a small level as with the purpose of avoiding competition. But they could achieve a similar result by doing a framework agreement so that they don't need to do a competition every time they want to buy it. They just do that once every 3 years, and then they just draw down from that framework agreement as and when they need it. And in fact, then a call-off contract looks like just a request for quotation almost, or it's just a purchase order. So very useful thing to do, and so be aware of that. That's something that the government is looking at, and so you may be able to benefit from that. You'd have a bigger market to supply. And finally, in terms of the procedures available for goods, works, and non-consulting services, is single source. And this was a waiver which was very uncertain and not clear. So now under the provisions of the Act and regulations, or under the Act actually, these are now set out so that they need to be justified. If the procuring entity is not going to use one of those previously described competitive methods, then to use this, they have to justify that they meet these grounds. The first one is one that happens all the time, not always properly. So you could use single source or direct contracting in cases of extreme urgency brought about by unforeseeable events, not unforeseen events. And I come back to Rob's explanation there, that not attributable to the procuring entity, and where there's no time to use open or restricted tendering. That's quite important. Everybody forgets that last little bit. But if you can use open and restricted, if there is enough time to use open and restricted procedure, then you can't use direct source, single source. And remember, it's not so long. I mean, you have to use it within 20 or 35 days, depending on whether it's a national or an international. That isn't actually so long. And we discovered this a lot in terms of the COVID emergency. At the beginning, of course, everything was a huge emergency. We had to buy everything straight away. But by the time we'd sort of settled in, sadly, to the routine of COVID, and we knew there were different waves coming, and all of that was fairly predictable, we had time enough to do an open or even a restricted procedure to buy a lot of the equipment or the vaccines that we needed. So it was no longer extreme urgency, which wasn't foreseeable because we knew it was coming. It was unforeseeable at the time it started, but after that, all the consequential events were perfectly foreseeable and were foreseen. So it's important to point out that if there is time to use an open or restricted procedure, then the single source is not available to you. But it's also an event that's not attributable to the procuring entity. So poor planning is not a reason for them to rely on single source. You know, they may say, oh, we've just run out of toner and paper. We need it urgently because we can't print anything. Well, should you not have should you not have looked in the cupboard 2 weeks ago? And if you fail to look in the cupboard, then sorry, it's your fault that this is an urgency. And no, you can't use single source. You've got to do a proper procedure. It's a way of correcting poor planning. And hopefully, when they start being rejected for use, when this waiver is no longer available, they have to justify the reasons for using single source, then maybe the planning will improve. They'll get the hang of it. But these are important conditions, and I think these are perfectly justifiable, and these are consistent with anything you'll see in the rest of the world. There is a ground for using it called emergency. I think that's covered by the first ground anyway in cases of extreme urgency. But it was in one of the original drafts, and lots of countries like having this word emergency in and defining it in whichever way they want. So it's still in there, but I do think it's covered by the first exception. The third one, and this is not necessarily in, or I think this is actually in the order that it appears in the Act, although that's not, I mean, there's no reason that it should be in this order. So I'm saying next just because it happens to be the next one, but it's not the next in terms of importance or anything. But you can use it for additional deliveries of goods and services by the original supplier, provided that original contract was awarded under a competitive process, and the value of the additional deliveries of goods or services don't exceed 50% of the original contract. Now, this has generated quite a lot of discussion, interestingly. Clearly, people want to use this sort of exception quite a lot. But it's not to be used where, for example, you say, oh, this supplier did a really good job, so I'm going to ask him to do the same again. That's not the situation. This is where you've got a contract that's underway, and you realize that you haven't got quite enough goods or services. So the example I've used up to now is, you know, you're building a school or supplying a school, and you thought there were going to be 70 pupils, so you needed to give equipment for 70. And as you're going through it, you realize actually there are some more students coming, it's going to be 90. So it's not a huge difference, but you've already got a contract in place for that delivery. And there really isn't any reason for such a small addition to go out to tender again, because there are costs involved. But if you did want to have much more, if you wanted to have another, you know, if it was, let's say it was 150, so it wasn't 70, but 150, then given the size of the original contract, it would be in your interest to do another competitive procedure, because of course the price you will get for that quantity is going to be less than what you would get for just an additional 20. So it's a little bit of working out what's going to be in your interest, what the value for money aspect is, but it isn't a license to go off and do another contract with the same supplier for the same quantity of goods.
And that's also an opportunity for suppliers to challenge that.
Yes.
Because if I was the supplier and I said, well, okay, I originally thought it was 70, it's now 200. If I'd known it was going to be 200, I would have done it completely differently. Therefore, I've been unfairly treated, I've been excluded, and so I should challenge. And again, that would be a decision which could be challenged as part of that, because you're actually saying is, well, this is now a substantially different arrangement to what it was in the original stage.
And I should say that the 50%, we've been asked a question, why 50%? Well, I suppose the answer to that is why not? It's a completely arbitrary figure. In some countries, it's 30%. In many countries, it is 50%. It's just to demonstrate that it's not going to be another contract of the same size. So you can only have additional deliveries a bit more. And 50% seems to be a very generous figure, but possibly a realistic one. The next ground for using a single source is for proprietary goods. So if a manufacturer has got a monopoly over a patent, for example, over the product, and nobody else can supply that product, then you can use direct source, provided there's no alternative, because you could have another supplier with a patent over his own product and both of them can be used for the same thing. There you can have competition. This would only apply where there is no alternative, where there is only one supplier. So that's something to bear in mind. It's not the existence of a patent, for example, it's the existence of only one patent. And that's something that needs to be borne in mind.
So again, vaccines would be one example.
Yes, yeah. There are at least 3 out there for COVID. You have to have competition between 3. You can't pick one and say, yeah, well, it's protected, so I'm going to go for that. No, that doesn't work. The next one is protection of national security. So you have to justify that it is a national security issue. Rob has already mentioned this early on. And so it's not the fact that you work in security, it's the fact that the product or the service you want is a national security product. So Rob mentioned buying boots is not a national security issue. Buying blankets or soap or whatever for your soldiers is also not a security issue. It's only things like munitions or special designed defense weaponry or something like that. That would be a national security issue. Or anything, for example, that the police force is using, which should not be publicized because it helps them in law enforcement or something like that. So there are these issues, but they have to be justified. And if it isn't justified and it's challenged, then the Procurement Appeals Board can overturn it and can say, well, actually, I'm sorry, that's not justification enough. And then finally, I mentioned in the case of consultancy assignments, but strangely not for goods, works and services, any contract that doesn't exceed $15,000 can be bought by way of single source. There's no other justification necessary, simply a question of value.
But again, the thing is that if it's simply a means of trying to disaggregate demand to keep them below that 15,000, then again, that's still in breach of that one. So it has to be a specifically standalone requirement, which is a one-off rather than part of a series. Yeah,
absolutely, absolutely. And so I'll turn lastly in terms of the methods available to request for proposals. These, I said, are for consultancy contracts. And really in any consultancy contract, you're trying to balance the technical and the financial. You're trying to see what the quality and experience is compared to what the price is. But the level of quality and the level of price will depend on what it is you're actually buying, because not all consultancies are the same. I've often used the example of accountants. So, an accountant who's giving you tax advice is actually quite important, and you want a good one to avoid paying too much taxes. I hope no auditors listening. But if you're just wanting a bookkeeper, then that's a set of procedures and processes that can be followed. That doesn't require very creative tax accounting. That's simply a question of bookkeeping. So you would be looking at different things. On one, you might be looking much more at quality. At the other end, you'd be looking much more at cost. I just need somebody who knows what they're doing, and then I want the cheapest price. But when I'm trying to avoid paying taxes, boy, will I be happy to pay more because of the one who can get me off the hook, as it were. So I mean, there are extremes even within. I was very shocked once. I was talking to the United Kingdom government representative on procurement. And we were trying to say, how do you distinguish between these? And they said, of course, lawyers, we just do it on price. And of course, as a lawyer, when I picked my chin off the floor, the shock that I heard, she said, no, I must explain. If we're going to court, of course, we want a really good lawyer. But if we just want the lawyer to convey the house, then we just want the cheapest lawyer. And that's absolutely right. So I was forced to agree that even in legal services, sometimes you just want you will award it on price, and sometimes you will award it on quality. And there are good reasons for doing that. And for that reason, you will also not want to negotiate the price on some of them, and you will on others. It's unfortunate the way it's drafted in the Act, I have to say, but there is a historical reason for that, and it was based on a model law out there, which isn't very clear. And so the result is that this isn't particularly clear. So I've tried to explain here. We had a problem earlier with all of these different acronyms, and I know they are complicated, but if you have a fixed budget selection, so if you only have a limited budget, then actually you're not looking at price competition at all. You're looking at competition on delivery and quantity and so forth. So it says, give us as much as you can for this price. So there's no need for negotiation there. There's no scope for negotiation. Similarly, if you're doing lowest cost selection, there's no scope for negotiating there, because you've already chosen the lowest cost. You can't reduce somebody else's cost. You might want to negotiate, on the other hand, where you are assessing quality and cost, because you might choose the highest quality, but you might say, hang on a minute, that the cost there is probably a bit too high. So I might still want to go with him, but I'm going to try and reduce the cost a little bit. The same thing if you're only looking at quality, which would be under something called the quality-based selection or consultant qualification selection, which is used in very standard processes, but where you might want to negotiate some of the terms and conditions. I don't know if you want to add anything to this. It's just unfortunate. I mean, I'm hoping that that's clear enough, but it is a little unclear in the law, I have to say, because of the terminology used. But that's how.
I mean, the general rule would be, if it's clear and can be defined clearly, and there is no flexibility in terms of what it is that's being provided, so it's almost an off-the-shelf service, then why negotiate? And there's no reason to negotiate, and you can't, unless you can justify that that's not the case, and you need then to seek clarification in terms of what it is, then most people should be done without negotiation. It's for those rare occasions where you say, well, I'm not really sure what this is done. It can be done in different ways. Therefore, who's going to be able to give me that opportunity to give me a better quality of service? But I will identify the basis and the weightings that I will apply on that process. So yes, I will have those, but you will see what the weighting is between quality and cost, so that whoever is going to submit bids in relation to that will be aware of what the criteria is and how that might work. And so the negotiation maybe say is, we may have to take out some of the elements in terms of the quality to drop the quality standards because we don't have enough money. We need to get it done. These things are optional. Is there another way that we can actually do it? So it's those kind of discussions and debates that will happen that will bring the thing to a conclusion. But where you don't have those uncertainties, it will be without negotiation, because you couldn't justify going the opposite route.
And that concludes the methods.
Okay, so in terms of, you've heard us talk again. Sorry, before I sort of move on, any questions from anyone in terms of where we're at? The other point would be is we're a long way into the session, and we haven't had a break. So would anyone look for a sort of 10-minute comfort break, or are you happy for us to continue through? And this is where silence means we continue through.
Yeah, I'm fine with continuing.
Okay, thank you. Right, I see you've got a chat. A bio break. Okay, let's just have a quick sort of 10-minute stop for people to refuel and whatever else they need to do in that time, and we'll come back. So it is now 20 past. So if we come back at past, then we'll finish the last lap through. Is that okay?
That's fine, Rob.
Okay. Is everybody back?
Yeah, we're here.
Excellent, thank you. Right, so as we move into sort of the last is you've heard us talk about aggregation already, and my apologies for appearing as if I was slowly disappearing into the gloom. As you probably worked out, I'm not on the same time zone as you guys, so it is dark here, so I've managed to get at least some lighting in there, although it does look as if I have a halo. So my apologies in terms of that. So in terms of aggregation, it's very
clearly some mistake.
absolutely, yeah. So clearly, in what the Act says is that, and it clearly states, shall not divide or use a valuation method for demand to limit competition and avoid the obligations of the Act. So classic would be is we're actually buying a distribution service, and so we're only going to value this contract for the 10% that's actually loaded for distribution, when in actual fact the contract itself may be worth 200,000, but because it's 20,000, I don't need to worry about it. And so again, that will be seen as no, it's a total contract that's in there. You can't simply find a way creatively of valuing the contract in order to avoid the rules. Equally, if you're looking at multi-year arrangements, so as we look towards some of the larger construction type contracts where you include an ongoing maintenance and repair service within the arrangement, then it's the value over the life of that arrangement, not simply being able to separate out the capital from the revenue consequences, because it's the whole package that would take through. Also, as we said, in terms of framework agreements, it's the value across the whole framework agreement, not individual elements of it. And it may well be that you're below the threshold on a one-year deal, but by making it a 3-year multi-year deal, that takes it over the threshold, in which case you're actually covered. So why do we want to do that? Well, one is so we can take the benefits of economies of scale. And it's about saying is not always saying that big is beautiful, but actually saying is, one, the more we procure and the more we understand how much we procure, then we should be getting a lower unit cost the more we buy. And so being able to take that principle on, rather than has been the case, is separating demand out, paying higher rates unnecessarily. Because in terms of planning, then having to produce an annual plan indicates what the thresholds are. And so people can see, you're actually spending $1 million on IT hardware, but we've not seen anything through in terms of tendering. So again, the annual plans that actually are produced identify those things which automatically will take them over the threshold and should then go through the full rules. Equally, as part of your plan, you can see those things which don't sit above the threshold, and we understand now when and how the procurement methods that are available to the procuring entity can be applied. And any variation from that, again, gives you the opportunity to be able to challenge that approach and that decision. And equally, if we have multiple procurement units being combined, so we actually say, well, we're actually going to do 4 different ministries, they have the same demand, therefore we're going to do a framework agreement for all of those, then it's the demand across all 4 units that actually takes it as a figure. And if that goes over the threshold, it's covered by the rules. And if we identify that people are splitting contracts to avoid the rules, then again, that's in breach of the law, and there are remedies available to be able to deal with that. However, saying that is what we can do is we don't have to award, because we consolidate demand, we don't have to award demand to one supplier. We can segment that demand into what's called lots. And so lots are effectively ways in which the procuring entity can look to segment the overall demand in ways which operationally make sense. And so it may well be on a technical basis. So we say we're going out for consultancy services, and we're going to separate it down from architects to quantity surveyors, to civil engineers, to mechanical engineers on that sort of basis. And so it will be a consolidated demand, but will award individual lots based on the individual technicalities. Or it could be on a geographic basis. So it's done on an island base, or even within islands on a base that would actually split it geographically. We can also say is what we want to do is to align the demand to what the capacity is available within the marketplace. And so this says is we recognize that if we award a contract for $5 million, there aren't many people who can actually deal with that. But if we award 10 contracts of $500,000 each, then that enables us, one, to ensure the marketplace has the capacity to deal with that volume of business, and also it ensures competition across the piece. So we can separate down capacity. It also helps if government says what we want to do is to develop and strengthen our SME community, because that's where BVI PLC will improve its return, and therefore what we want to do is to help support them on that basis. And so again, we can do it on capacity. Equally, we can say is what we're going to do is we're going to put, so lots will apply on a time base. So for the first quarter, second quarter, third quarter, on that sort of base, so you can award lots over time to allow means within a single procurement to give multiple opportunities, or indeed any of the reasons that come through, as long as those reasons can make sense and can be justified. And so that's the whole sort of basis. So you can't, so the procuring entity can't come up with some very weird and wonderful reason as to why they're going to award it on lots. If it can't be justified, then it would be in breach and it would not be allowed and could be challenged. So where they do offer lots, then this must be clearly made known to the marketplace. Now, good practice would be to notify before the procurement contract starts, so the marketplace is aware of what the procuring entity is trying to do, so that they can gear themselves up to take that on board. But at the least, it must appear in the bid document, and that must say how many lots will be awarded under the procurement and the basis upon which the lots would be determined. So what's the basis of the lots and how many are there going to be? Also, are bidders able to bid for single lots, so you can only bid for one lot, or are you able to bid for multiple lots? And if you are able to bid for multiple lots, what's the process by which the allocation and the evaluation would take place to be awarded multiple lots? So it may be that the matrix in terms of the pricing structure says is I could award lot 1 and lot 5 to one supplier. I could award lot 1 and 2 to a supplier. I could award 1, 2, or 3. And if that happens, what's the implications and how would that be priced as part of the package within the contract? Also, on what basis will the award be made? So the award criteria, the evaluation criteria will be identified. So in terms of bidders, so we'd look at response times, delivery lead times, maybe in terms of product range, maybe in terms of availability, expertise. And so whatever criteria would be applied would be identified in the bid document and would be listed in usually descending order of importance. It may well be in some instances they actually say is this is how the weightings will be applied. So it's very clear, very transparent in terms of how the procuring entity will determine the winning bids, so much so that once it's identified there in terms of the weightings, the bidders will know exactly how to construct their pricing package in order to best align itself to the evaluation criteria that's going to be used. Where you've gone through the process and there's 10 lots within the package, but there's only bids for 8 of them, what the entity can do is say, well, for the 2 that didn't, is it because the criteria that we got, so the technical profile didn't match? Is it because there was availability, so the size of the package, geography of the package didn't work? So what we can do is we can then adjust those outstanding lots, repackage them in a way which the marketplace will be comfortable with, and then reissue a new bid document for those outstanding lots. However, you can't split lots where you're simply trying to avoid the threshold, or where if you award separate contracts, it creates problems in terms of compatibility. And so it may well be is that what you say is we've got a contract for mobile phones, and because it's not compatible in terms of Apple or Samsung or whoever it may be, then that's the basis in which we're actually going to split our lots. What we would say is that's not really a suitable means by which you can separate it out. And so that would be an opportunity to challenge that basis as part of the procurement. Equally, that it actually makes it much more administratively complex, because one of the key things, as was mentioned earlier, is it's about efficiency and economy. And so if it makes it more administratively unwieldy in terms of how you actually done it, then again, that would not be a suitable grounds in terms of supporting the justification to award lots. We've talked a lot in terms of thresholds. What I want to just sort of finally sort of tidy those up. So thresholds are important because in terms of being able to award lots and being able to consolidate demand, but it also in terms of distinguishing responsibilities. So it clarifies the role. So procuring committees know what they can and what they can't do, and what has to be referred up to the procurement unit. Equally, they know what they can approve and what has to be sent up to the tender board. They know how and what part of the law applies, so whether it's covered or whether it's excluded. They also can see which procurement method can be applied. So they know, based on the value of that, what they can and what they can't do. So can they do single source? If the value is above the threshold, the answer is no. And so the defense that's been in the past is, I didn't know, has now gone away because all of those elements have been identified. And so hopefully there is no gray area within that. And also what it's designed to do is to align competition to the marketplace, to make government procurement more attractive to the supply market. And we've seen is that it allows small companies to be able to compete. It also, because of the aggregation issues, makes it competitive for the larger companies to be able to do that. And because we're looking at things other than lowest price, those suppliers in the past who would say, well, I'm never going to be the lowest, because lowest price is always the way in which they will award it, there is no point in me submitting bids. That's no longer the case, and actively people are being encouraged to look at other than lowest price. And so demonstrating value for money, having the means to justify those other non-price-based issues can be incorporated, not least of which will be the sustainability elements that as part of the policy documents that will be coming through shortly. So in terms of key thresholds, above 100,000 is the procurement unit for goods, works and services. Above 10,000 to 99,000 would be within the individual procurement entities to be able to sort of deal with either through their own contracting or quotations. For goods and services, less than 10,000, it's just simply a purchase order, but supported by evidence of competition sourcing within the marketplace. And for single source, less than 15,000. In terms of approving the decisions, so if a contract is over 100,000 but below 250,000, then the Central Tenders Board would be the one that would make that decision. Above 250,000, it would go to Cabinet. And so those are the key numbers that need to be taken into account in terms of where it actually goes and how it's actually going to be awarded. Any questions on those? Okay. So again, hopefully what we've been able to say is good procurement practice, which is what we're encouraging, will give you transparency. So we can see now, hopefully it's much clearer what the processes are, how people make the decision in terms of what procedure to follow. What are the options in terms of that's built into the law to ensure everyone gets treated in exactly the same. Also that in the event of people feeling aggrieved, then there are sufficient protections available to not just government, but also to the supply community, that in terms of confidentiality. And again, one of the issues that was there is, why should we engage with the procuring entity on coming up with innovative solutions when all they do is simply take our good ideas, incorporate them into the specification, and therefore our competitive innovation gets subsumed into a common description? And the answer is, one is ensuring confidentiality within that. And so what we're saying is, where you're looking to define the requirements, let's think in terms of performance rather than conformance. And so rather than have a huge document which specifies every single thing in there, and then it simply cuts and pastes innovative options from suppliers, we're saying is, no, this is what our need is, and all we're looking at doing is, does this need work? Well, is there a better way in which we can actually do it? And if so, how can that actually work in terms of achieving performance? It also will ensure compliance because we've addressed every element within the procurement process. So there are now no hiding places, no areas of uncertainty that people can say, sorry, I didn't realize that was the case. It was my mistake. As actually saying is, well, now it's clearly identified, and this exercise that we're doing is part of that sort of process, is to actually say, this is what compliance means. But equally, this is what good procurement means, and good procurement will ensure compliance. And also, people now understand that they should declare any interests that they may have, which is likely to be seen either actual, perceived, or proposed, in terms of causing potential problems. As long as that's identified, it's minimized that risk, then it will take people through the process to give us good procurement. So last part, ladies and gentlemen, and if I can just ask for one part before we go, when I stop my screen share, you will all appear on my screen. So if I can ask you at that point to put on your video, I can then demonstrate that you've all been there and you've all been avidly listening to me for the period, so we can see what's what. Thank you. So bid submission periods. Again, what we've said is that you see words like reasonable, adequate time, and so and what we're trying to do in the sort of next slide that you come to is to try and put some sort of timescales in place as minimum to make it realistic for people to say, yes, that's a sensible timescale for me to be able to, one, prepare my bid. So first I have to read it, understand it, then determine what I need to do. and then having determined what I need to do, get all the costs and get all the processes in place to be able to say, yes, I can now identify what it's going to cost me, and then I can submit my bid, rather than it be saying, right, we've got 7 days to do it, and we know realistically there's no one who's going to be able to do that, or it's designed for an individual who may be able to do it in that scale, therefore that's unfair. So we're putting in times which are seen as being reasonable and appropriate for people to do that. Clearly, these would be minimum time periods, and the more complex it is, it should be allow longer timescales, without that timescale being inordinately long as to make it again almost impossible to be able to quantify and to hold pricing for the timescale in terms of validity period. So, in terms of the law itself, minimum periods. So for open bidding, 35 days between advertisement and date for, excuse me, oh dear, for submission, or 28 days if it's domestic. In terms of limited bidding, then on the basis that you've actually gone through and done some sort of pre-screening as part of that, you'll also have fewer people to be able to evaluate. Then they brought the timing down to 21 days or 14 days in the case of domestic. So those are sort of recommendations, and those are minimum standards within the law. But if we take the overall procurement process, what we're saying is there are some areas which aren't defined, but we need to be aware of what the implications are of not having that defined. So the annual procurement plans should be ready and issued out within 30 days of budget approval. And that's really saying is, I'm going to be spending 5 million on IT, hardware and software. I'm going to be spending 5 million on office sundries and so on. So again, you can look within your own business sector and see what the likely opportunities will be coming through within the next year, and also whether or not it extends beyond a year. For the entity to define the need, and again, what we said is within the process, there's no fixed time in terms of being able to define the need, but what we're saying is make sure you get it right. So it's getting it right first time, because the more areas of uncertainty, the greater the need will be in terms of bid clarification. The greater the need for bid clarification, the longer the timescale it will be, because you'll need to give people time to be able to assimilate the new information and to be able to address that within the bid that they're going to submit. And also, it doesn't help matters if it's so unclear, it makes it unattractive in terms of suppliers. So in terms of qualifications, so pre-qualifications, again, it's saying is that 20 working days, I stress in terms of working days rather than calendar days, to be able to do that. So again, what it's saying is you'll have that sort of time in order to be able to put together the information needed in order for the qualification process to take place. I've talked through in terms of the bid document that's in place. The other part is in terms of the validity of bid. Again, one of the criticisms have been is that it takes so long for the procurement. And so what we're saying is that really you should be looking at being able to make your decision within this kind of timescale, and 60 days would seem to be reasonable. If it's going to be longer than that, then you need to say, this is how it's going to be. But also bear in mind that the longer it is, the harder it becomes for bidders to be able to put together a sensible pricing structure. And so what we've said also in terms of bid security, one, if the bid security is needed, and again, we've said, think about the value of a bid security, because it simply adds cost rather than value. Then if you are requiring that, then it should be no more than 28 days beyond the timescale for the bid validity period, on the basis that that's how long it should take to be able to decide and to be able to get a new bid process in place. Equally, in terms of the bid evaluation, that period is not defined within the law, but again, what it should be is it should be a sensible period. So again, you should be taking no more internally to evaluate the bids than the bidders take to prepare the bids. So it would not be unreasonable to see the bid evaluation periods the same as in terms of bid document issue and return timescales. And that's again something that we would say is that makes it attractive, because if it takes longer than that, then either the need definition is not clear enough, or it's too complex to be able to do that, and the evaluation criteria that you put in the bid document is not sufficiently robust enough to be able to do it. The next part is, so having evaluated the bids and having determined who the successful bidder is going to be, we notify all the unsuccessful bidders that we've made our decision and that they have been unsuccessful in this particular procurement. However, the award is not made for another 10 days. And effectively, that's the timescale that the unsuccessful bidders have in order to be able to, one, seek clarification, either through the debrief of the procurement entity for their decision, or if they think something untoward's happened, and to make their challenge. So within that challenge period, so within that 10-day period, that's the time that you have to be able to say, I think there's something untoward and I wish to make a challenge. If it's after that 10 days, then your ability to be able to challenge lapses. If you make a challenge, then in terms of the review, they will have up to 5 days after the issue of the award notice to make that, 15 days after the issue of the award notice to make their decision. And the decision has to be made within 10 days of their choice. So making the request within 10 days, the decision has to be notified. Equally, your ability to be able to be debriefed is within that 10-day period. So effectively, you've got this 10-day window in which everything goes on hold until that time lapses. At that point, the successful contract would be awarded. And what we're saying is the procurement process should realistically be no longer than 90 days from the bid return date. If it's any longer than that, then again, the likelihood that you're getting value for money diminishes the longer that process takes, because you have to estimate what the likelihood in terms of cost. And if we take what's happening at the moment, just simply in terms of fuel prices, it's nigh on impossible to be able to set what the level is going to be next week, never mind in 90 days' time. Also importantly, if an application for review is made, that's a suspension, which is what Peter said earlier on. The process is suspended, so it goes into hold until that review is carried out. Unless it's urgent, in which case it may well be that they say, yes, okay, we recognise that there is a challenge made. However, we need to do that. We'll award the arrangement because we need to do it now, but there will still be remedies available to you in the event that your challenge is successful. And at that point, ladies and gentlemen, I'm going to say we stop for this session. We have another session with you tomorrow. So hopefully we'll be able to take that through. And what we propose is that we have a Q&A session afterwards. So please feel free, if you have questions, to prepare them in advance and send them through to us. And we'll try to incorporate that in there. But what I also suggest is, I'm conscious that time is precious to you all. So if we run the session through 9 o'clock until 12 o'clock, to finish off our input, and then run straight into the Q&A session, which will run for as long as you have questions to ask us. If that makes sense, that's what I'll propose to do. Okay. So if you could all open your, thank you. If you can just open your roles, then we can actually sort of see you all. That's absolutely splendid. I am very grateful for that.
Sorry, we don't actually have cameras in our office.
Okay, okay. In which case, thank you very much for those of you that have done. Great stuff. Other than that, I wish you a pleasant afternoon and evening, and I will see you all tomorrow morning. Before we go, any questions, anybody?
Yeah, I have a question, if you don't mind.
I never mind questions. I welcome them.
So in the appeals process,
yes,
you mentioned that first it goes to the ministry, and then they pass it on to the appeals board. And then you mentioned a third level after that without much clarity. What is it? Like if the appeals board rejects an appeal and the bidder is still unsatisfied, what's the next step?
Yeah,
we did. I was going to say the first thing is it's the procuring entity is the first point before it goes to the minister. Sorry, Peter.
Okay.
Yeah, no, I think I did say 3, and I failed to define the third one. You're absolutely right, I remember. So the first one is to the procuring entity, then it goes to the procurement appeals board through the minister, but that's just a logistical issue. And then if either party is dissatisfied with the way in which the procurement appeals board has applied the law, they can take it to the High Court, but that would be on a point of law. And we hope it never gets there. I mean, the idea is that the people appointed to the Procurement Appeals Board should be able to come to a satisfactory solution. I mean, they're going to be people who know about procurement and hopefully know about the sectors that are involved. But constitutionally, you should always be able to go to the High Court, and that would be on a point of law. So if you think the Procurement Appeals Board has failed to apply it properly, then you can appeal it to the High Court.
Okay, thanks. And then while we're on the topic of challenges, that 10 days to challenge after the notification of award, is that 10 business days or calendar days?
That's 10 working days.
Working days. All right, thank you.
You're welcome.
Rob, was that 10 days in reference to when they can challenge?
Yes.
Or that 10 days was in reference to given the minimum time, minimum periods?
It's the standstill period, yeah.
Yes, so the 10 days is from notifying all the unsuccessful bidders that they have been unsuccessful. They then have 10 working days to then, if they feel after having a debrief that the decision that's been made is not the correct one, they can then make their challenge. But the challenge, once that 10-day period has lapsed, then their opportunity to be able to make that challenge also lapses. Which is why the procuring entity has to make any request for debriefing available and to do it within that time.
Okay.
Also, if, again, just on a mind point, is if the challenge is made or the request for debriefing is made and it's sort of 9 days into it, then clearly the person who receives the debriefing must be given a reasonable time to be able to make that decision, unless they said, well, you know, and I'll do it on that way and I'll buy myself some more time. But if for genuine reasons they've not been able to get that debriefing done, then it should not be unreasonable to allow them a sufficient time to be able to analyze what's made out of the debriefing in order to then say, yes, I still want to make the challenge.
Okay.
Okay, ladies and gentlemen, thank you very much for your attendance. I look forward to seeing you all in the morning, and enjoy the rest of your evening.
We see you tomorrow.
All right.
Same
thank
to
you.
you.
All right. Take care. Bye.